Hi, everyone. Hello, this is Rafina Rashid, immigration and citizenship lawyer here in Toronto. I am coming to you today from my home because I'm still self-isolating. I want you to know that Yellen and I are still available to assist you in any way possible. Even though we are working remotely, we can still be reached by email or phone. This is our third video that we're posting with regards to how COVID-19 is affecting immigration matters. So we have the other two videos, one on travel and the other one on processing of immigration applications, posted on our firm's Facebook page. So if you weren't able to join us live, you can view them at any time there. Today, what I'm going to talk to you about is employer obligations, specifically with regards to employers of temporary foreign workers. As we mentioned in the previous video, temporary foreign workers fall under the exemption category, and they are still permitted to travel to Canada, even though that there is a travel ban on most other individuals traveling to Canada. So in addition, there are many temporary foreign workers who are employed by Canadian businesses who need to maintain their temporary status while they're here in Canada. So I'm just going to go over a few of the things that employers need to be aware of and ensure that they're doing, because this could come back to haunt them if they were ever in a compliance, audited for compliance from ESTC. So what do employers need to know? Employers of temporary foreign workers need to know that those temporary foreign workers must self-isolate for 14 days once they enter Canada. And they need to have a plan for self-isolation. What we've been told is that the assessment of the plan is being done before the individual boards the plane. So it would be helpful for the employer to communicate with the employee about what kind of plan they will have in place. For example, if employment of accommodations is included in the offer of employment, the employer should let the employee know where they're going to be housed, and with guarantees that it will meet the public policy specifications, that being 2 meters away from anyone else and not in contact with anyone who would be considered vulnerable. So anyone who's sick, elderly, or has a medical condition that might put them in a special situation. So employers also need to know that the term of employment starts from the first day of entry to Canada. So and that includes the self-isolation period. One of the questions that we've been getting from employers is, do they have to pay the temporary foreign worker during the self-isolation period? And the answer is yes. The employer needs to pay the employee for 14 days at a minimum of 30 hours per week. And the rate of pay is determined by what was agreed to in the labor market impact assessment. And the employer can withhold benefits, contract benefits such as EI, housing, and transportation, but they can't deduct any of the costs that they're incurring because of the self-isolation. So they can't claw any of that back. And this requirement applies to individuals we call farm workers, so individuals who come in under the seasonal agricultural worker program. Their self-isolation period needs to be paid in addition to the minimum 240 hours that's specified in their contract. The government has recently announced, I believe it was earlier this week, that they are going to be providing assistance to farmers and businesses in the agri-food industry to assist with the payment of this self-isolation period, because they recognize that it is a burden on these employers, but we still need these workers to come in, and we still need to maintain public safety and health of all Canadians. What else do employers need to know? They need to know that the workers cannot work during the self-isolation period. Some workers are exempt from this requirement of self-isolation, and it's a very small group. They include individuals such as truck drivers who are moving from one end of Canada to the other, and also crossing the border between Canada and the United States, and possibly even Mexico. Those individuals don't need to self-isolate each time they enter Canada. Also, medical staff that are coming in from other parts of the world to assist us with the COVID-19 pandemic that we're facing. So employers also need to know that failure to comply with the self-isolation period, the mandatory self-isolation period, comes with fines and possible imprisonment depending on the severity of the non-compliance. And this falls under the Quarantine Act. So the maximum penalty includes up to $750,000 or imprisonment for up to 6 months for simple non-compliance, not permitting your employee to self-isolate. Or the individual will face this fine as well. So that's another thing that employers need to know, is that if their temporary foreign worker is not complying with the self-isolation, they could be fined if they are found to be in breach. Persons who cause a risk of imminent death or serious bodily harm to another person face a fine of $1 million or imprisonment of up to 3 years. So the amount of the fine gives you an idea of just how important the self-isolation period is to the Government of Canada and to everyone who's living here, to maintain public health, and also to just flatten the curve so that we can get past this pandemic. The federal government is also considering penalties for employers of foreign workers under other streams, other regimes such as the Immigration Refugee Protection regulations. That hasn't been announced yet, but they have put it out there that they are considering other penalties. So what are the requirements for employers who need to provide housing? Employers who have a requirement, such as under the Seasonal Agricultural Worker Program, accommodations must meet minimum standards. And the minimum standards are fourfold. First, there has to be adequate spacing between individuals. And this, we know from the public policy announcements, is a minimum of 2 meters apart at all times. The employer needs to ensure that the temporary foreign worker is in self-isolation and separated from individuals who are not in self-isolation. So we can't be mixing up groups of people, which means that the employer is going to have to keep a separate facility accommodation for temporary foreign workers who are coming in at different times. And the third requirement is keeping self-isolated workers away from older adults and those with medical conditions who are at risk of developing serious illness. And the last one is providing the worker with materials that they need to maintain sanitation, such as soap and warm water and a place where they can wash their hands. Question that we have received recently is from a client whose work permit was approved, and they want to know if their employer must provide them with accommodation while they're in isolation. So the answer to that question, just in general, is that it really depends on the terms of employment. So if the offer of employment includes the employer providing accommodation, then that would be an obligation on the employer. And also with regards to the program policy. So as I've mentioned, the seasonal agricultural workers accommodation provision is part of their program policy. If the offer of employment and the program policy do not place that obligation on an employer, then there is no requirement for the employer to assist with providing accommodation for the self-isolation period. That burden falls on the temporary foreign worker and also has to be included in their plan before they travel to Canada. Another question that we received recently is, what are the employer's responsibilities with respect to isolation if a worker develops COVID-19 symptoms after the self-isolation period? So the temporary foreign worker has finished their 14-day self-isolation, they've started working, but now they're showing symptoms. They're either coughing, they have fever, or they're having respiratory issues. So the employer has an ongoing obligation to monitor the health of all employees, whether it is a temporary foreign worker or a Canadian citizen or permanent resident, and report to local health authorities anyone who becomes symptomatic. So if the employee becomes symptomatic, the employer must arrange for the employee to self-isolate. This might require them to send them home, or to, if they are providing accommodation, to ensure that they are in a facility where they're not interacting with people who are not supposed to be in isolation at the same time. And then the employee must call the public health officials, and the employer might also want to call consular officials, depending on what country the individual is from. The employer has to make sure that the self-isolation continues for 14 days from the first day that the employee exhibits symptoms of COVID-19. So that leads us into the topic of what are the responsibilities of employers with regards to sick or laid off workers. So a question that our employer clients have is, does a Canadian company have to pay an employee who gets sick with COVID-19? Again, the answer to this question is that it depends. If the sickness takes place during the self-isolation period, then the worker has to be paid as per the government requirements of the employer paying for the employee during the mandatory first 14-day isolation. If the worker starts showing symptoms after the 14-day isolation period, the provisions available under the employment contract might kick in, such as paid sick leave or other benefits. If they don't, then the worker might be eligible for employment insurance or the new Canada Emergency Response Benefit. In both cases, the temporary foreign worker is subject to the same eligibility criteria as a Canadian citizen or permanent resident. So EI sickness benefits are available for people who are unable to work due to illness, injury, or quarantine, but who would be available otherwise if it weren't for their medical condition. And there's a minimum insurable hours criteria, so they would have to make sure that they meet that. And the recently announced Canada Emergency Response Benefit will provide temporary income to support workers who are without employment due to COVID-19. So this includes workers who are temporarily have stopped working, or have lost their job, or are sick or in quarantine. So that benefit might be available to temporary foreign workers if they meet the criteria. Following along the same lines, a question that has come up is, will workers receive health care coverage while they are in Canada, including related to COVID-19 related issues? So this really depends on the province, when it kicks in, which province or territory the individual is in. But generally, temporary foreign workers should receive the same coverage as Canadian citizens and permanent residents. For workers of low wage and the agricultural stream, if the provincial and territorial healthcare coverage is not provided from the first day the worker arrives in Canada, the employer must provide private healthcare insurance until the worker is eligible for the provincial or territorial coverage. Under the current circumstances that we're dealing with, some provinces and territories are waiving the eligibility period, waiting period. So this is something that employers would need to look into and confirm with the jurisdiction in which their business is located. So employers usually have to notify Service Canada of any changes in employment conditions, such as layoffs, or if the individual is working from home, or a reduction in salary. And this is important to keep in mind, as I mentioned at the top, that there are compliance audits that are done from time to time with employers, and in order to ensure that you're complying with the original requirements of the program, employers need to make sure that they're not, for example, laying off temporary foreign workers disproportionately to Canadian citizens or permanent residents. So they need to ask themselves, how are other workers being treated? Is everyone being laid off? And make sure that they're not specifically targeting temporary foreign workers. With regards to asking a temporary foreign worker to work from home, this might fall into a non-compliance if the work permit conditions don't allow for it. So they would need to check what the location of employment is on the work permit. A reduction in salary is usually not permitted. However, there might be justifications that can be made, and notations should be made in the file with regards to the economic conditions and if all employees are impacted in the same way, just to ensure that, again, temporary foreign workers are not being disproportionately targeted in an unfair manner. So Service Canada is still processing labor market impact assessment applications. The ones that were currently in queue, and they're accepting new ones. And they have let employers know that there's no need to advise them of every single minor administrative change to the terms and conditions of the LMIA. They are currently issuing LMIAs for 9 months instead of 6 months. And they are waiving the recruitment for agriculture and agri-food sectors until October 31st of this year. So anyone who would be submitting an LMIA for an agriculture, agri-food type of position does not need to do the 3-month recruitment as per usual until the end of October of this year. And then we'll see what happens and how things are going. There might be further announcements with regards to this. The LMIA in key occupations related to agriculture and agri-food business is being prioritized for processing, so they are focusing on those applications over any others for obvious reasons. We need to continue the food supply chain, keep it moving. And another alert that Surveys Canada has put out is that the maximum duration for employment under the labour market impact assessments is increased from 1 year to 2 years for employers of workers in the low wage stream as part of a 3-year pilot. So that means that's sort of a break for those employers. They don't have to apply every year to continue the employment of that individual in that low wage position. It also saves them $1,000 every time they have to apply. So employers applying under the agricultural stream or seasonal agricultural worker program, they don't need to submit the housing report each time as of now. They can use one that was previously approved. And the last bit of change with the LMIA program is the name change process for employers who, let's say they identified one worker in their LMIA application, but that person's no longer available or no longer interested, but the employer still wants to use that LMIA to bring someone else in. Surveys Canada is trying to expedite these name changes, and they're trying to do it within 1 day rather than 5 days. A recent question that we had is from a individual in Mexico. Their employer is here in Canada and received a positive labor market impact assessment in January, but the Mexican national can't travel to Canada right now, and they want to know if the LMIA can be extended. So extensions for LMIAs need to be done by the employer. So the employer needs to make the request. And usually the extension is for 1 month, but under the current conditions, Surveys Canada is providing 3-month extensions. So I'm just going to check to see if we have any other questions, and it does not look like we do. So that pretty much wraps up any of the updates that I wanted to provide today. Yellen and I are available. We are providing free 15-minute consultations to help anyone who has questions with regard to how COVID-19 is affecting their immigration situation, whether it be wanting to travel to Canada, or they have a pending application or want to submit an application, or employers who are not sure how to, navigate the landscape. I will post on our Facebook page the links to sign up for the free 15-minute consultation. And as I mentioned, we are also available by phone and email at any time to answer any questions or assist you. So I hope everyone stays safe and healthy. And Yelena will be here next Thursday to talk about another topic. I believe it might be sponsorship applications, but who knows what will happen between now and next Thursday. Some other issue might come up that might be more pertinent. In any case, join us next Thursday at 11 a.m. and stay safe, everyone.